Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. So without any further ado, I would love to introduce our program and our speakers today. So again, the presentation is entitled Civility in Action, Fostering Professionalism in the Legal Profession. And our speakers today are Judge David Rosen, Judge Winifred Smith, and Attorney Mark Kramer. So beginning with Judge Rosen, throughout his career, Judge Rosen has demonstrated an unwavering commitment to upholding justice and promoting effective dispute resolution methods. His deep-rooted understanding of the law, combined with his approachable demeanor and empathetic nature, make him an invaluable asset to those navigating the complex realm of alternative dispute resolution. He has extensive trial experience from both sides of the bench. As an attorney, Judge Rosen specialized in civil litigation. He briefed and argued over 20 cases of various types before the California Courts of Appeal, 2 cases before the Ninth Circuit Courts of Appeal, and 4 cases before the California Supreme Court. His expertise spans personal injury claims, professional liability, products liability, business disputes, environmental and toxic tort actions, insurance disputes, real estate matters, and employment matters. Thanks so much for joining us today, Judge Rosen.
Thank you, Katie.
Next, we have Judge Winifred Smith. Judge Smith came to ADR Services, Inc. with 21 years of experience as a judge of the Alameda County Superior Court and 26 years as Deputy Attorney General in the California Attorney General's Office. Judge Smith has extensive experience in a variety of civil cases, including coordinating cases, class actions, employment, constructive defect, and Prop 65 matters, and has presided over many cases presenting questions of first impression. In her 13 years serving in civil assignments, Judge Smith presided over nearly 100 cases to verdict, including a product liability and complex litigation case, which resulted in the largest civil award in California's history. She's been affirmed in 95% of her cases on appeal, and with ADR Services, Inc. as a full-time neutral, Judge Smith is widely respected for her judicial demeanor and her ability to deftly manage very complex matters to resolution. Thank you for bringing your expertise to us today, Judge Smith. And finally, last but not least at all, we have Mark Kramer. Mark, drawing upon a career spanning over 4 decades as both a mediator and a trial lawyer, utilizes his extensive experience to assist parties in resolving disputes, bringing invaluable expertise to the mediation field. He's formerly a partner at the distinguished Los Angeles firm Fonda and Garrard, and Mark established Kramer and Kramer in 1992. Throughout his career, Mark has tried over 50 cases to verdict, demonstrating his expertise across a diverse spectrum of law. And beyond his work in insurance defense, Mark demonstrates versatility through his handling of plaintiffs' matters. In addition to his litigation and trial experience, Mark distinguishes himself through his extensive mediation experience as well. With over 2 decades of service to the Los Angeles Superior Court as a mediator and arbitrator, Mark has facilitated hundreds of settlements with tact, efficiency, and a deep understanding of the law. And now with ADR, his practice epitomizes trust, proficiency, and a steadfast commitment to equitable resolution. So with that, I will pass it over to Judge Smith to take the lead on our presentation here.
Everyone's talking a lot about civility in the last few years. I know that I've sat on at least 4 or 5 panels where civility is the topic of conversation. And we're talking about it for a lot of reasons. There is this new MCL requirement for civility education, which is why we're here today, which requires an hour of education addressing civility in the legal profession. So why did that become necessary? My thoughts on it are that over time, it was always assumed that everyone involved in the legal profession would be civil. And I think for the most part, people are civil. However, there are times when I think it has evolved that people feel that incivility as a strategy seems to work for them, and that it has become a little bit more difficult to navigate litigating cases when you are dealing with people who don't want to be civil. So the California legislature has taken action, and it actually has instituted Rules of Court 9.07, an amendment, which now requires that practitioners annually reaffirm the lawyer's oath. And since 2014, when it was changed after a very, very long time, included a pledge to be civil in the practice of law. Having to reaffirm that would remind all of us of sort of what our basic responsibilities are as lawyers. That at a base level, we need to essentially treat people like we want to be treated. And we need to remind ourselves and our colleagues that as we navigate litigating cases and as we navigate just the profession of law, that it's important to maintain that, because it allows us to actually do our business in a way that is more efficient and that allows us to make some progress. And I know for judges, it allows a case to be litigated more efficiently, and it is less time consuming when you're not either navigating the squabbles among lawyers or spending time dealing with issues that otherwise you wouldn't need to if the litigants wanted to be or chose to be civil to each other. Next slide.
Judge Smith, before we move along, would you mind sitting a little bit closer to your microphone? Some are having a touch of a hard time hearing you.
Okay. Let's see. Is this a little bit better?
That is a little bit better. Thank you.
Okay, good. So, what is civility? In some ways, it's sort of you know it when you see it, or incivility is something you kind of know when you see it. Some people equate civility with wokeness. Some people resist it, even including the need to reaffirm the oath or to legislate civility into the practice of law because they didn't think they needed it. Sometimes those are the people who need it most. Civility is really just being conciliatory, collegial, professional, and aware of how you are behaving and how you are managing your interactions with other people. It doesn't have to be friendly, but it does have to be respectful. And the California Rules of Professional Conduct have now enacted what's called, people refer to it as the snitch rule, but actually it's an ethical obligation to report incivility when it occurs or when you see it. And I think this is for a number of reasons, and Judge Rosen and Mr. Kramer can chime in here, but in fact, the need to be civil when you are conducting business is one of the things that results in a number of things. First of all, your reputation remains intact, because that's really what you have when you are practicing law, but also you are able to manage your cases more efficiently. You're able to get the work done. And I think that's really important and paramount when you're thinking about what are you doing as a lawyer? What are our obligations to each other, and what are the results when you're not civil?
Judge Smith, let me just interject something. You see, all can see on the slide a reference to the report of the California Civility Task Force, which I think we're making available to you. That task force really did the work over a period of a couple of years, led by Appellate Justice Brian. I'm just drawing a blank on his name, but in any event, they did great work pointing out the need for civility. Most of the rules relating to civility have been in existence for years. And as you'll hear in a few minutes, the cases that talk about incivility go back really decades in California. But the report of the task force is really what inspired the bar to move and change the rules to which Judge Smith was just referring. One part of the report talks about reactions that the task force obtained or heard from from lawyers when asking about whether we needed to have civility rules. There were a lot of people that thought it was a great idea, but there were a lot of people quoted in the report who thought that having civility rules was going to infringe upon their ability to practice, infringe upon their ability to zealously advocate on behalf of their clients, and so forth. Part of our aim today is to show you the distinction between zealous advocacy on the one hand, which of course is still encouraged, and incivility on the other. The last thing I wanted to, last interruption I wanted to make had to do with the, Rule 8.3, the so-called snitch rule. As so often happens, California adopted that rule from the model rules of professional conduct, requiring lawyers and courts to report not only on lawyers who are uncivil, but lawyers who are breaching the rules of professional conduct. California was the last state to adopt that rule, the last of all the states. Right around the time we were adopting that so-called snitch rule, we were adopting the changes to the civility rules, or the addition of the civility rules. And some might see them as contradictory, but they're really not.
Ray, one of the cases, incivility is sort of thin in the gears of justice as it slows litigation and makes it more costly for all involved in a short time. Sometimes it's just with the judges having to resolve disputes that aren't necessary. Did you finish, Judge Smith?
I'm sorry, I can't hear you.
You finished?
Yes, I did want to just add one thing, and that is that incivility is not just the things that we say to each other, but it's also our conduct. So I think that people think that just how you speak to people, maybe the way in which you conduct a deposition, sort of the scorched earth approach or the insults that are thrown around are uncivil. But incivility is actually not only sort of your words, but your deeds. The kinds of things that delay, interfere, or otherwise are inappropriate or unnecessary in the conduct of a case, discovery, denying a request for a simple request for a continuance, or in combination with the intent to have a particular outcome, negative outcome, may be considered uncivil. So as you're thinking about incivility, it could be strategy as well as words. So it's conduct and it's words. And cannot, I don't think, underscore enough that now it is required that both judges and lawyers report uncivil conduct. It is an obligation to report that now. So it's not just an agreement that we're all going to be civil, but there are real consequences to it.
Thank you. I've been asked to talk about conscious versus unconscious behaviors. Conscious behavior is something when you make a decision, hold the door open for someone, which is obviously
Mark, I'm so sorry to interrupt. Can you also sit a little bit closer to your microphone? Apologies, everybody. Some of our speakers are on borrowed setups due to the situation in Los Angeles. So please bear with us with the audios.
Thank you, Katie. In any event, conscious actions are something like holding the door open for someone, making a decision to do that, whereas or negative conscious action would be purposely ignoring somebody in a group discussion. Unconscious actions are when you reflexively reach to stabilize somebody who's tripped over something, or saying something like, "You're so articulate," which in essence implies that you were surprised that the person is so well spoken. Now, biases are seen as aggression, such as a woman clutching her purse when she walks by a person of color, something like that. Two cases dealing with these issues are Brigante, where in an appellate brief, the sides are described for no particular reason the trial judge as an attractive, hardworking, brilliant, young, politically well-connected judge on the fast track for the California Supreme Court or federal bench. Although the appellate court did not feel this would change anything in the case, they did note that this was gender discrimination as a subcategory of a larger scourge of instability affecting the legal practice.
I'm sorry, Mark. We're still having a little bit of trouble with the audio. Do you have anything sitting on top of your microphone, perhaps?
That I know of.
Could you move a little bit closer to the mic again?
Yes, sorry, everyone.
That sounds much better now where you are.
In any event, the court in there found it uncivil and unacceptable. And the Merrick case, the trial judge actually said in making his final ruling on the case that noted that it was almost amusing to see this little Chinese woman stare me down because she didn't like the ruling. once again, that did not affect the appellate court's decision on the case, but the concurring opinion of presiding Justice Stratton noted that that could not pass without censure and stated that trading on racist and sexist trope was an implicit bias and manifested in microaggression. Anything else that you, Judge Rosen or Judge Smith, want to add to that?
Well, I
I
would just
would,
add that, you know, when we're talking about biases, I think the first thing you have to do is acknowledge that we all have them. That's that's natural as humans, but I think that being aware of them and doing things to make sure that you are aware of your biases and are addressing them when you are dealing with other people goes a long way, I think, to developing habits where you are conscious of who you are, conscious of who you're talking to, and I think it makes being civil, or at least guards against being uncivil, when you're kind of more aware of your behavior and your biases. So I think that's one of the things that need to be thought about. And there are lots of kinds of biases. I mean, I think that biases are basically when you're categorizing people, sometimes stereotyping people, but it's not often associated with race, but it could be anything. It could be whether people have tattoos, whether people have whether they're heavy or they're thin or they look like you or they don't look like you, and how you react, or whether you are aware of how you are reacting to people who perhaps are different from you. You know, conscious bias is one thing it's more intentional, but unconscious bias is really very prevalent, and it's one of the things that I think we all have, and I think one of the things that we have to sort of inspires a lot of self-examination. And I think once that happens, it will go a long way to having people acknowledge that maybe they're being uncivil when they don't think they are. So something to think about.
So bias can cause and catalyze incivility. And as Judge Smith just said, there are certain kinds of bias that are talked about and should continue to be talked about so as to avoid them. But there are other kinds of bias that we don't talk about or think about much that can indeed lead to incivility. How our adversary is dressed. A judge can often have bias and sometimes react with less than civil behavior to someone who they feel is not appropriately dressed for court. Someone's family background, whether they're from a so-called traditional family or a different kind of family. Geography, where people are from, within the United States and without, the dialect that they use when they speak, their accent. None of those things have any impact or reflect the person's intelligence or preparation for whatever proceeding they're engaging in, but they can affect your view toward them and can promote incivility. Age and generation. Those of us of a certain age, which I guess it's fair to say are the three presenters on this program, are well aware of colleagues who raise questions, shall we say, about those of other generations, either older than us or certainly younger. That kind of bias, even if unconscious, can result or lead to incivility. And of course, today, political views not only express views, but more commonly, what you think or what you presume your adversary, your colleague, or even the bench officer's political views are, even if you don't actually know what they are, can lead to bias, which can lead to incivility. Just a few more quick examples. Educational level or background of the witness you're talking to, practice area or side of the area that is plaintiff or defense of your adversary or the lawyer that you're talking to, and of course, professions, jobs, and careers. These are all things that can result in unconscious bias and which can catalyze incivility.
Thank you, Dave. Well, this one's civility as a career move. The first point under there talks about civility being secret weapon or courteous behavior, secret weapon in trial. I had a month-long trial many years ago, and I will tell you that another attorney I knew had warned me, if you will, about one of the plaintiff attorneys that he was less than pleasant to deal with. We tried to make it a quote-unquote personal battle. Well, when the case ended, we had two different jurors came up to me afterwards and said they didn't particularly like my clients, but they sure didn't like the way the attorneys were acting towards me and not treating me with any civility. And that came out with a nice verdict completely in my client's favor. But that was something I hadn't realized the jury was picking up on necessarily. And it wasn't a conscious decision on my part. It was just the way I tend to be and would always be in a courtroom, I think. Um, as was mentioned, reputation is something you have. The judges talk, I'm sure, about attorneys, how they talk about, and the clerks talk about attorneys, etc. It's very important that you keep your reputation good and that people think highly of you. To that end, a lot of attorneys think that they have to be almost a bully. They have to be tough and mean for their client. Maybe they think they're putting on a show for their client or something. The second firm, this is a career decision, if you will, workplace culture and courtroom culture. The second law firm I worked for, the senior partner praised his quality of a-holiness. And maybe I should use the other word, but you can all understand that. After I'd been with that firm for a little less than a year, came to my office and told me he was convinced I was really a great guy and a great attorney, but he thought that I could be doing even better if I became more of an a-hole. He then had a list of every case I've worked on in the firm, every case that I'd resolved, 20, 30 cases, went through every single one of them, one after each one, and said, wow, that's a great result. Wow, well, that's good. Yeah, that's really good. And after finishing the whole list, he said, well, I can't find anybody. Still feel there must be one somewhere, but you could do even better if you'd be more of an equal. In any event, the first firm I'd been at, the senior partner and all the partners were genuinely nice guys, and they didn't practice that way. They didn't have any desire to become practicing that way. And I quit and left the firm the next day. Judge Smith, Judge Rosen, you wish to add anything to this area?
Sure, I think that it cannot be overemphasized that workplace culture can lead to incivility, and it's important to point out to lawyers that there may be pressure, both because it's the culture in wherever you're working, or client expectations that you are uncivil because they want to see the kind of adversarious, I guess, that they imagine will make their point. That kind of thing can get you into trouble, even more so now than ever. I mean, I think the way you conduct yourself is important. Your reputation coming into the practice and leaving the practice is pretty much what you're going to have. And so it's important to maintain that reputation. But I think even more importantly, you cannot allow outside pressures to cause you to be uncivil, whatever they are. If the culture, if the expectation in your workplace culture is that you are not civil in the practice of law, then it might not be the workplace for you. Because ultimately, if you are disciplined because you are behaving uncivil to anybody, litigants, your clients, court staff, anybody that you're coming in contact with, not only is your reputation damaged, but you may suffer some consequence with the bar. So it's important to remember that you always have to maintain your own integrity and act accordingly if where you are working isn't the place for you, or there are pressures, outside pressures, that are causing you to become incivil, or there's an expectation that you are going to be uncivil.
As far as workplace culture goes, I know that a lot of the people who are sitting for this seminar today, this webinar, run their own office. And it's something to think about, to set a tone. You've all heard the expression that you need to set a tone with respect to professionalism, with respect to preparation, with respect to aggressive advocacy. But you also need to set a tone in your office of civility. Law offices take on the personality that their senior partner or partners show, just as courtrooms often take on the personality that the judge shows. When I was a lawyer, I was aware of courtrooms where the judge was, shall we say, difficult, and typically the judge's staff was also difficult to deal with. That's even for lawyers who knew that they should be civil to everyone, not just other lawyers or not just the judge. There were a couple of questions on the Q&A already about whether these civility rules apply to judges in their dealings with lawyers and others, and the answer is resoundingly yes. There was also a question about judges not really enforcing civility even when incivility is reported. And obviously, it's going to change from courtroom to courtroom, but I would point out that these rules and the focus on them are new, even though the concept is far from new. Judges are taking continuing legal education just as often and frequently as you all are, and they will be learning just as we all are about setting the proper tone.
I just want to add you can very fairly zealously represent your client and get great results, even if you do it in a very civil manner. And, I've had some hard fought trials where both sides was rather sure of their position. And some of those people ended up being something against, best friends. One I had a long case against, and we probably talk 3 times a week about them. And the same thing with other attorneys I opposed to. Here's, thank you very much. And I think it's passing to you, Judge Rowe.
All right, I think we go to the next slide now. Thank you. So I mentioned before the task force report on civility, and specifically Appendix 3 to that report is where the task force, or as I joked about a little bit before, the law clerks for the task force gathered something like 110 cases, California cases primarily, talking about incivility, uncivil behavior, and the results thereof. As Judge Smith said earlier, incivility, like obscenity, is something that you know when you know it when you see it. It's hard to define in the abstract. By the way, for those who are keeping score at home, the citation for obscenity is something that you know when you see it is the Jacobellis case, a 1964 case from the Supreme Court, 378 U.S. 184. You might want to take a look at it. Next slide. Before we actually get to that, I wanted to give you a few examples from the appendix of the task force about uncivil behavior and uncivil behavior being sanctioned by the court, either by exclusion of evidence, by admission of evidence, because under 352, for example, a court has a lot of discretion to make a decision about admission or inadmission and can be affected by uncivil behavior lately, and in these cases, against the person being uncivil. The Sullivan case, which is an unpublished case from 2018 in the appendix, talks about ad hominem, personal attacks by one counsel against the other. In the Sullivan case, specifically in closing argument before a jury. Among other things, the uncivil lawyer engaged in the popular but very erroneous misquote of Shakespeare that the first thing we do is kill all the lawyers. Students of Shakespeare know that that actually was a compliment to lawyers because that quote was spoken by someone who wanted to engage in a chaotic society and knew that if you get rid of lawyers, it's easier to do that. But the point in the Sullivan case was that one lawyer referred to the other lawyer as being the object of Shakespeare's quote that all the lawyers should be killed. Certainly, that lawyer was sanctioned by the trial court for that kind of ad hominem attack, and those sanctions were upheld. In the Carton, K-A-R-T-O-N case, which is in the appendix and which is found at 61 Calap 5th, 734, this is a 2021 case, and I think one of the questions asked about it, one of the questions today, there was a reduced attorney's fee award. The one party asked for $292,000 in attorney's fees. The trial court reduced that attorney's fee award to $90,000, a pretty significant haircut, all would agree, because of ad hominem attacks, personal attacks, engaged in by the lawyer whose fees were being presented against the other lawyer. And that significant cut was upheld by the Court of Appeal for those reasons. Two more cases. The Kim case, which is at 201 Calat 4th, 267, a 2011 case in which a lawyer was sanctioned by the trial court, a sanction which was upheld by the Court of Appeal because the lawyer lied, just bald-faced lied on multiple occasions during the litigation of the underlying case in court and in papers. And finally, perhaps the one that hits home the most in defining what crossing the line is, what is uncivil or what is incivility going beyond aggressive practice. And that's the LaSalle case, L-A, new word S-A-L-L-E, 36 Calat 5th, 127, a 2019 case that focuses on default practice. There are a number of cases collected in the LaSalle opinion which talk about the contradiction, if you will, or the tension between the statutory rules for when default for a non-responding party can be taken and, according to the courts of appeal, when it should be taken. LaSalle itself and the other cases which are cited in the opinion talk about lawyers who wait for the 31st day and without any warning, without even an email, text, or phone call, they immediately set about to taking the default of the non-responding party. As you may know, if you've ever gotten involved in default practice, those sorts of defaults are routinely overturned by the court for most any decent excuse for the failure to respond by the non-responding party. And so that kind of a default without any warning, without any attempt to cure the default or to have the other lawyer cure the default, results in a lot of wasted time for counsel, for the parties, and of course for the court. And that circles back to another part of the reason that the task force and now the bar wants us to engage in civil behavior. All of us are overloaded. The court systems are, of course, overloaded. And we cannot waste time redressing lawyers' failure to be professional with each other. Defaults are a classic example of that. And under the LaSalle case and others cited in that case and since, people will be sanctioned for taking a default without warning. Okay, next slide. Actually, the slide we had, I apologize. Sorry about that. I'd gotten ahead of myself. So we're talking here about the crossing the line or threading the needle between zealous representation, aggressive practice, which is entirely appropriate on the one hand, and professional incivility on the other hand. The Tuft article, which is cited there on the slide, is a very recent article from the Litigation Section magazine. I think it was either from December of last year or even this month. And it talks about the historical tension between these two concepts. Further, the standard may shift. It may be different. What is uncivil in one kind of case may purely be aggressive representation on the other. The example we gave you there is of the difference in aggressiveness in which one might engage in defending someone accused of a capital crime on the one hand, and the aggressiveness in which someone might engage in defending a client accused of breach of contract on the other. These kinds of differences are accounted for in Rules of Professional Conduct, Rule 3.1, and the rules within the sub-rules within that. All of this points to the necessary understanding that civility is not black and white. It is somewhat subjective and it depends on the circumstances. But in any event, the point is that zealous advocacy, aggressive representation of your client is not uncivil. And engaging in civility at the same time is not a contradictory concept. Think about maybe these examples. On the one hand, is going to mediation, agreeing to go to mediation without any intent whatsoever to resolve a case, but simply to take the time to go. Is that zealous representation, or is that incivility? Or think about something that all of us learned about in evidence class back in law school. That's the concept that just because you can object, just because the evidence code would support an objection to a question, a motion to strike to a question, an objection to an answer, or an objection during opposing counsel's opening statement or closing argument. Just because the evidence code might support your objection does not mean that you should make the objection. Why? Not because you don't want to be a nice person, but because you don't want to appear to the judge or the jury, God forbid, as being obstreperous. Maybe that's the difference between aggressive representation on the one hand, which is objecting where you must to protect your client's position, and obstreperousness and incivility on the other hand, where you are objecting simply because the evidence code technically supports the objection or to break up your opposing counsel's pace. The point is that engaging in civility is wise, not just because it's required and not just because you're a good person, but because it helps you do a better job of representing your client and not hurting your client's case. All right, now we can go to slide 8, please.
Before we go to slide 8, or as we go to slide 8, I'd just like to add that sometimes I think the distinction between civility and incivility can really be the difference between sort of making an argument passionately and then being personal in some way. When you devolve into the personal, I think you're pretty certain to sort of get over to the uncivil side. So it's one thing to say, oh, all the lawyers should be killed. There's some sort of abstract point, about lawyers in general. But then when you focus it on someone and say, well, you're the guy who's really one of the lawyers that should be killed, then you have kind of moved into an entirely different area. And I think that often people are concerned about whether they're being zealous versus, just being passionate. But a lot of times, in many of the examples, including things that are said by judges, are things that involve pointing, your speech at someone personally and insulting them, degrading them, humiliating them, and doing something that is inappropriate when you can make the same point by being passionate, but not making anything personal.
The case law to which I referred earlier, not just those specific cases, but the others, absolutely supports what Judge Smith just said. There is that difference. And if that's not enough for you, anyone who's ever tried a jury trial as a judge or an attorney is aware from talking to jurors of what Mark Kramer talked about earlier today, and that is juries don't like to see personal attacks. They're okay with seeing attacks on the evidence. They're okay with seeing attacks on testimony or on a story, but they don't like personal attacks. And so again, being civil is all about protecting your client and advancing their position. All right, on this slide, we just have a little story that comes from a very recent federal district court opinion down in Alabama, just from late November of last year. This case involved the time-honored distinction that civil lawyers are aware of, which is where a defense counsel contacts plaintiff's counsel and says, can I get an extension of time in which to respond to the complaint? And the plaintiff's counsel says, thinking they're being tricky, well, I'll give you an extension of time in which to answer the complaint, which is another way of saying, I'm not going to give you any more time to prepare your demur or your motion to dismiss or whatever the case may be. That's what happened here. The defendant, because the defense counsel, because the plaintiff's counsel wouldn't give him an extension of time in which to respond, files a motion to extend the deadline, which lies more in federal court, which the plaintiff counsel then conditionally opposed unless the defendant agreed to answer the complaint only. This is a classic example, not only of what the federal judge Proctor called wholly inappropriate and fiddle-faddle, but it's a classic example of wasting the court and counsel's time in needless law and motion practice. The bottom line is, it is not less than aggressive or zealous representation to engage in civility and grant a first extension of a reasonable time for the other side to respond. Now, where would the line fall differently? If you knew that the lawyer on the other side routinely asked for multiple extensions and then didn't grant them to the other side. That's underlying facts which would render something uncivil or change it from being uncivil to being zealous advocacy. Next slide, please.
Judge Rosen, before we move on, would you mind saying once again those 3 cases that you referenced from the Civility Task Force report, Appendix 3?
Sure. The first one is one of the first 2 or 3 cases cited in Appendix 3. It's an unpublished opinion from 2018 called Sullivan. That's the one where the lawyer in closing argument misquoted Shakespeare on killing all the lawyers and then made it personal as to his opponent. Second case was Carton, Karton, 61 Calat 5th, 734. This was where an attorney's fee award, which would otherwise likely have been justified, it nearly totally, if not totally, was reduced severely because of personal attacks engaged in by the lawyer whose fees were being sought. 2 more cases, Kim, 201 Calat 4th, 267, lawyer engaged in lying, abject lying. And finally, the case on sharp default practices, not giving the opposing side any kind of warning that you're going to take a default unless they contact you or respond in a reasonably timely fashion after the deadline. That's LaSalle 36, or LaSalle, I guess I should say, 36 Calat 5th, 127.
Thank you.
Thank you.
I've posted them in the chat for everybody as well.
Thanks. Okay, slide 9 gives 2 more examples, which I think were listed in the appendix, but which we pulled out because they are so impressive in terms of their discussion of uncivil behavior. First, the La Jolla Spa case, which is out of the Federal District Court in the Southern District down in San Diego from about 5 years ago. In that case, counsel was extremely rude to the point of being referred to by the court, by the trial court, as atrocious behavior at depositions. Specifically, one counsel was attacking not the good faith of the other counsel, but the legal ability of the other counsel. Here again, personalizing the attack, as Judge Smith referred or mentioned just a few moments ago, to such an extent and to such a repeated extent over several depositions that the rude and atrociously behaving lawyer was sanctioned by the Southern District Court. And finally, the Davenport case from 2011, you see the site there on the slide. This is a very important case to family law judges for a different reason than the reason it's cited here. Davenport famously recites the presumption that a sitting trial court knows the law and properly applies it. It's a rebuttable presumption, but in family law, it's particularly important because, of course, the judge is both the trier of fact and the trier of law, and often the parties are, one party or both are unrepresented. So that holding of Davenport is important. But the rest of Davenport is the reason it's cited here. In this case, counsel was cited by the trial court, sanctioned by the trial court, and upheld in that sanction by the Court of Appeal for persistent and repeated rudeness to both the court in court and to opposing counsel in court, in emails, and in depositions. So it's sort of the La Jolla Spa case writ large. All right. And I think now, oh yes, this is still me. All right, very quick tutorial on workers' compensation. Most of you may know that workers' comp exists to compensate workers for injuries or deaths suffered in the course of doing their work. That's what that's why this slide is here, because it is the far end, the far reaches of incivility. I participated in a case many years ago, which resulted in the widow of an attorney receiving a workers' comp death benefit because that attorney's death was considered to be work-related. Not particularly interesting in and of itself, but the facts make it interesting. The attorney in this case took his own life and left a suicide note in which he indicated that he knew that he was rude and that he was, not his words, but uncivil and engaged repeatedly in incivility throughout his practice. He knew that he was disliked by his own partners, his own associates, and nearly all, if not all, of his adversaries, as well as the courts before whom he practiced. And he said in his suicide note that he did not know how to practice any differently, drove out to the LA County border out in the Antelope Valley, and took his own life. This case resulted in the application of the irresistible impulse doctrine of workers' comp, which says that where a suicide results in an irresistible impulse to take one's own life because of the work, then that death is compensable as a work-related death. That Chu case talks about irresistible impulse, not the case I'm telling you about. But the point that I'm trying to make is incivility can go far and deep and have the kind of result that I just explained to you. Now I'll hand it back to Judge Smith.
So I think the question was posed earlier whether or not these rules apply to judges as well as lawyers, and yes, as Judge Rosen pointed out a little earlier, absolutely they do. The judge is responsible for upholding the integrity and the independence of the judiciary, and all of the rules and the canons of ethics that apply to judges make clear that judges are required to be civil. They are required to uphold the integrity and the independence of the judiciary by behaving in a way that is essentially a model for the lawyers and other people who are observing them. So it's important to know that there not only are the obligations of the judges to report uncivil behavior, but for lawyers to report uncivil behavior about the judges and the way they're treated in court. And I think this, although I don't know of any specific examples, would extend to staff as well. Really, if you're talking to the judge's staff, you're talking to the judge. And I think that cuts both ways. Certainly you want to be responsible and civil in the way you behave with court staff as well as judges, but the court staff's obligation to treat everyone who comes in that courtroom in a civil way, I think is an extension of the judge's obligation to be civil. So I think we always have to keep that in mind. And if you can go to the next slide, I think that the way in which the judge conducts him or herself in the courtroom, sets the example and sets the tone for litigation in their courtroom. I noticed a comment earlier in the chat where somebody was citing a case in the southern United States where a judge was telling a woman in court that she was dressed inappropriately. I don't know anything about the case or the circumstances under which that comment was made, but it's an example of a couple of things. One is, I think it is uncivil because that judge probably has absolutely no idea that may be the only clothing that person had to come to court. I'm not sure the circumstance under which a judge would comment on a woman's clothing or anyone's clothing actually in court. They may have a personal view that someone is dressed inappropriately, and certainly I've seen people in courtrooms where I kind of wonder what they thought when they put that on and came to court. But to point that out publicly and sort of turn an eye, which sort of addresses a little bit what I said earlier about being personal, is that you have to be very careful with that kind of language and that kind of behavior. Just as an example, I think if that judge felt that that person was dressed inappropriately and perhaps felt they should leave, and there may be someone who comes in the court that way, there may be ways to address that by subtly asking a member of the court staff to speak to the person. I mean, if that's necessary. So I'm sort of talking a little bit in the abstract because I don't know anything about the case, but I do think it is an example of the judge's obligation to set the tone and tenor in a courtroom, and essentially an example for the lawyers. Um, Microaggressions can come from the bench just like they can come from anywhere else. Judges have to be aware of their biases and the way in which they address people. I think that Mr. Kramer made the earlier example, the case where the judge was sort of commenting on a woman's ethnicity in court, which would be inappropriate. The judge may not have felt or been aware that making that comment, and probably wasn't, I'm sure the person would not have intentionally insulted her, but to be aware that that kind of thing can be insulting is just what I was referring to earlier about having some check on your own behavior and your own biases and your obligation to be aware of what they are and to act accordingly. The Code of Judicial Ethics, Canon 1, Rothman's 8 pillars are, just sort of the cornerstone of the way in which the court should behave, and the civility that is required towards lawyers and litigants. And it's, I think one of the things that we probably all ought to be aware of is that there's less physical interaction with people in the courtroom. And I think sometimes when when you're there standing there talking to someone face to face, you may have a different way of interacting than if you are seeing them on a screen and you are one of several people on a screen arguing to the judge. I noticed that during COVID, when we went to remote hearings, I think people felt a little more comfortable saying and doing things they might not have had they been standing there facing the court or their opposing counsel. So it's really important to be aware if you are in a remote setting as to how you're conducting yourself. And are you conducting yourself differently than you would have? Are you being as sensitive as perhaps you need to be and should be, and civil in a way that you may not feel that you need to do that when you are in a remote setting? So those are some of the things I think to think about, because I'm not sure that it's really going to be different as we go forward. I think that remote hearings are here to stay, and so that's something that we need to be aware of and sort of build into the way which we behave. Building relationships, which relies on civility in our post-COVID world, is exactly what I'm talking about, which is that the way in which you interact and build relationships with co-counsel, opposing counsel, and the court is something that is the way, I think, the way of the world going forward. So you want to build in what is civil behavior in that context. How should I behave, and if I'm what does incivility look like as well? What are the kinds of things that the remote setting sort of lets the barriers down that might allow you to say and do things that you might not otherwise do? So that's something that you always want to have in mind as you are navigating the post-COVID world in the way in which discovery is conducted and that sort of thing. So keep in mind that it is probably a new world in some ways. You may even be doing trials remotely. I know I did one before I retired. I don't know if that's still happening as frequently, probably not, but those kinds of hearings and trials are likely to continue to happen. So keeping in mind the way in which you are navigating the post-COVID world is really important.
On this building relationship, now that people aren't going to court as often, when you get a new case, you may want to just pick up the phone and call the other attorney, introduce yourself, talk about things, and just build a relationship. You might even set up a Zoom meeting where you can put a face to the name, know who you're talking to. You don't understand something in email, you might want to pick up the phone and call them, hey, John, David, Sally, whatever. I didn't understand what you meant here. Can we discuss that? If you want to move on to the next slide. This is this thing called civility. It talks about extending courtesy. It's important reputation. It's already been touched on, but the clerks talk to the judge and any courtroom staff. You should be anyway, but you want to be courteous to them. You don't want them going and saying, Kramer's a jerk, Your Honor, such and such, you did this, you did that, whatever. You want to have a good reputation. Extending courtesies. There are some attorneys that try to be make it difficult on the other side, if you will. holding papers to compile them so that somebody else has to work on a holiday weekend, that sort of thing, to get a response done. To shorten the time, giving them minimal time to respond, that sort of thing. Extending the courtesy. In fact, those of you that can remember the Northridge earthquake, there was a day about 4 or 5 days after the main quake where there were 3 different 5.0 plus aftershocks in the same day. Our office was on the 5th floor at the time, and I had the pleasure of riding up in the elevator in one of those. I came in and everyone was pretty shaken, if you will, so I told everyone to go home, don't worry about it, and the whole staff left. Shortly after that, I don't remember if the mail came or it was a delivery, but I got a new file and it was due. If it was a Friday, it was due on Monday, or I think it was due that same day. I called the plaintiff attorney and asked for an extension and let him know that the whole staff had gone home. He too had experienced the aftershock. He said no, he wouldn't give me any extension because he didn't like the way the insurance company had dealt with him. I tell you, I pleaded with him. I said, hey, well, the whole staff has gone home. I've never dealt with him. I haven't given him a hard time. My assistants haven't given me a hard time. Just give us 1 day extension even. He wouldn't do that, absolutely wouldn't do it. I mean, there was just no reason to do that. I consider that very incivil, if you will. And there's no reason to be that rude, if you will. Parenthetically, he was disbarred about 3 or 4 years after that. Having nothing to do with my case, but just wasn't a way to practice. There was no reason for him to be that rude. And I had to call my secretary who had gone home shaken and ask her to come back to the office so we can get an answer on file. Because I'm sure he was one of those people that's been discussed already that we've taken a default, 8:30 the next morning as soon as he could. Once again, your reputation is important. Attorneys talk, certainly lawyers talk, judges talk. Thank you. I don't know if Judge Smith or Judge Rosen want to add anything to that.
I wanted to add one quick thing so that I don't get sanctioned in any way, and that is the Court of Appeal Justice who chaired the task force on civility is Brian Curry. I could not remember his last name, having a senior moment that I did. Brian is the presiding justice of Division 4 of the 2nd District. Just wanted to give credit where credit was due.
I just want to make one closing comment because we almost run out of time. I saw a couple of comments in, in the Q&A, concerned whether or not there would be differing standards in different places depending on people's perception of what's uncivil. And that may be true, but what I would say to you is that incivility isn't going to be, and I don't think that it is intended to be, just a minor sort of infraction of the rules or sort of a minor transgression, and I think it's intended to address really serious and persistent behavior. I doubt that you're going to find that the bar or any other organization, for example, the courts, are going to want to litigate issues involving a slight as opposed to something that's obvious and truly insulting. So I don't think there's a concern that there's going to be an arbitrary application of the rule. And so I just think that if you stick to the basics and treat people the way you want to be treated, you'll probably go a long way to satisfying the rules of civility, and it will not impede your ability to be a zealous advocate for your client.
One of the questions I see on the list is, would it be uncivil to make reference to a party's nationality in a pleading where it is irrelevant to the matter, i.e. about a plaintiff or defendant in a personal injury case? And I think that would most likely be found to be uncivil or incivil, however you wish to characterize it. And I would point out the case I spoke about earlier, the Merrick case with the talk about the little Chinese woman that the court found inappropriate. On that basis, they're somewhat racist, if you will. And also the Brigante v. Chow case, both of the sites for both of those were in slides, which I didn't intend to have. And in that case, the court particularly noted that it was inappropriate and to irrelevantly note that the trial judge was attractive amongst other things. And I think the same would extend to bringing out the nationality of a party of the litigation when it's not relevant to any of the matter being dealt with in the court. Thank you all.
Thank you, everybody.
Well,
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.